Thank you for joining us. This is a Quinn Emanuel webinar. I'm Dan Posner. I'm a partner in the firm's Los Angeles office. I focus on intellectual property litigation, including copyright litigation.
My name is Viola Trebicka. I am likewise a partner in Quinn Emanuel's Los Angeles office, and I also focus on, among other things, intellectual property litigation. So thank you for viewing this Quinn Emanuel webinar. We'll take about 30 minutes to discuss two recent developments in copyright law that are important for both practitioners as well as copyright owners to know about. In particular, we'll focus on discussing the holding, reasoning, and practical implications of two Supreme Court decisions that were both issued on March 4th, and they were both unanimous rulings overturning decisions by the Ninth Circuit. And they turn on matters that relate primarily to the statutory construction of the Copyright Act.
Specifically, the two cases we'll be talking about today. The first one is Rimini Street versus Oracle USA. And that case held that full costs, as used under the Copyright Act, does not include expenses beyond 6 categories of enumerated costs that Congress identified in the general cost statutes. The result of that ruling is that available costs are now quite narrow in copyright cases. The second case is the Fourth Estate Public Benefit Corporation case versus wallstreet.com. That case held that copyright registration occurs, and a copyright claimant may therefore commence a lawsuit for infringement when the Copyright Office issues a certificate of registration, and not merely when a copyright owner submits an application to the Copyright Office, as certain circuits, including the Ninth Circuit, had held. We'll start by talking about the Rimini Street case.
Yeah, so the question presented in Rimini Street was whether the copyright's allowance of full costs under 17 U.S.C. subsection 505 to a prevailing party is limited to the taxable costs under 28 U.S.C. subsections 1821 and 1920, as the 8th and 11th circuits have held, or whether it also authorizes non-taxable costs, as the Ninth Circuit had held. Now, this question is important because it affects the incentives that parties may have to bring copyright cases and to aggressively litigate them, particularly through expert discovery, which can be quite expensive in a copyright case. Full costs is the phrase at issue, and it's found in 17 U.S.C. subsection 505, which specifically states that in any civil action under this title, the court in its discretion may allow the recovery of full costs by or against any party other than the United States. The very next sentence says that, except as otherwise provided by this title, the court may also award a reasonable attorney's fee to the prevailing party as part of the costs. Under 28 U.S.C. subsection 1920, the enumerated taxable costs are only 6. It's the fees of the clerk and marshal, fees for printed or electronically recorded transcripts, things like that, docket fees under section 1923 of this title, and notably absent from subsection 1920 are expert witness fees, consulting fees, and also electronic discovery fees. And as any practitioner knows, those can be quite substantial in a litigation, particularly in a copyright litigation. The other cost statutes that's at issue, 28 U.S.C. subsection 1821, provides that a witness shall be paid an attendance fee of $40 per day for each day's attendance. And that's notably very small compared to fees that private litigants normally pay their experts, for instance. The decision of what full cost means was against the backdrop of a pretty developed Supreme Court jurisprudence with respect to the term costs. The first case, Crawford Fitting versus J.T. Gibbons, Inc., a 1987 case, there the Supreme Court decided that costs taxable under Rule 54D are limited to those set forth in subsections 1920 and 1821, and that any argument that a federal court is empowered to exceed the limitations that were specifically set out in those subsections without plain evidence of congressional intent to supersede those sections ignores longstanding precedents. The next Supreme Court case, West Virginia University Hospitals versus Casey, was a 1991 case. At issue there was 48 U.S.C. subsection 1988, which gives district courts discretion to award the prevailing party in civil rights cases, again, a reasonable attorney's fee as part of the costs. And the Supreme Court found that that specific phrasing did not clearly evidence Congress's intent to allow a prevailing party to recover expert witness fees. And the final case in the Supreme Court trio of cases was a 2006 opinion, Arlington Central School District Board of Education versus Murphy. At issue was the Individuals with Disabilities Act. And there, the phrase in the statute read that the court may award reasonable attorney's fees as part of the costs. And again, the court found that this phrasing did not clearly evidence Congress's intent to allow prevailing parties to recover expert witness fees. And what is very apparent in all three of these cases is that the court was not willing to broaden the term costs beyond the subsections at issue in the general cost statutes 1920 and 1821. So against this backdrop, there had been a circuit split with respect to the term full costs in the copyright statute. So full costs versus costs. The Eighth Circuit, in a per curiam decision, 1996, Pinkham versus Kamex, had found that the use of the words full costs did not clearly, explicitly, or plainly evidence congressional intent to treat the Copyright Act costs differently from the costs authorized in the other statutes. And the 11th Circuit followed suit in a per curiam decision in 2001. However, the Ninth Circuit had found otherwise. The Ninth Circuit had found that full costs includes non-taxable costs, such as expert witness fees. And specifically, in a decision in 2005 in 20th Century Fox Film Corporation versus Entertainment Distribution, where, the court had latched on the term full before the term costs, finding that was clear evidence of congressional intent that non-taxable costs should also be available. The facts of Rimini Street versus Oracle, not really that important to the holding of the court. Oracle had secured a verdict against petitioners Rimini Street for innocent copyright infringement and violation of state anti-hacking statutes. And importantly, Oracle had more than 20 claims against Rimini Street and succeeded only on one claim. It had sought more than $18 million in non-taxable costs, almost $8 million in expert fees, a few $100,000 in consulting fees, and more than $8 million in electronic discovery costs. The district court winnowed that down to $12 million in non-taxable costs, and following Ninth Circuit's holding in the 20th Century Fox case, found that it had to award those as non-taxable costs since Oracle was the prevailing party. And on appeal, the Ninth Circuit again affirmed the district court's award of the non-taxable costs, again explaining that it was bound by its own prior precedents. The Supreme Court set down a very clear rule in overturning the Ninth Circuit. It found that a statute awarding costs will not be construed as authorizing an award of litigation expenses beyond the 6 categories that were listed in subsections 1821 and 1920, absent an explicit statutory instruction to that effect. And it found that the Copyright Act did not explicitly authorize the award of litigation expenses beyond the 6 categories that are specified in the general cost statutes. It found that the Copyright Act authorizes federal district courts to award full costs to a party in copyright litigation, but that term simply means that it's the costs that are also outlined in the general cost statutes. It rejected all of Oracle's arguments. For example, Oracle argued that the word full authorized courts to go beyond what was specified or enumerated in the general cost statutes. The court said, we disagree. Full is a term of quantity or amount. It's an adjective that means the complete measure of the noun that it modifies. So for example, the court said full moon still means moon, doesn't mean Mars. The second argument that Oracle brought is that the term full costs in the Copyright Act is a historical term of art that encompasses more than the costs that were listed in the relevant cost statutes. And the court said, Well, no. As an initial matter, our decision in Crawford Fitting explained that courts should not undertake extensive historical excavation to arrive at the meaning of the terms in the statutes at the time that the statutes were enacted. Importantly, however, the court went on to do just that and undertook an historical excavation and held that Oracle's historical argument failed even on its own terms. Now, this is important because there's a question of whether this forebodes a new era of statutory originalism. There was a Supreme Court opinion that was issued the day after the Rimini argument, penned by Justice Gorsuch, in which he wrote, words generally should be interpreted as taking their ordinary meaning at the time Congress enacted the statute. No justice other than Justice Ginsburg actually took issue with this. The third argument that Oracle raised is this idea that there would be surplusage if full costs essentially means costs, that the term full would not have any meaning in and of itself. And the court said, well, no, because for two reasons. First is that Oracle's interpretation would create its own redundancy problem by rendering the second sentence in subsection 505, which provides for an award of attorney's fees, largely redundant. And second, that in statutes addressing costs, there will be some redundancy, some surplusage. That's hardly unusual, the court said. And that's also another important provision in this opinion that could have more far-reaching consequences than just with respect to this issue. One unanswered question from the court's opinion, which is whether a district court has discretion to award an amount in between the full costs and no costs. That's something that the court recognized as something that was unanswered, but said we do not and need not consider that argument now. Whether it will come up in another opinion or in another case, although we may note that the costs that are awarded according to the general cost statutes are not as large as to make this an important issue for litigants necessarily. And finally, now that the Supreme Court has spoken and has said that non-taxable costs are not recoverable by a prevailing party under the Copyright Act, the question is whether Congress will act and correct that. A large portion of Oracle's non-taxable costs, about $8 million, was attributable to expert witness fees. And of course, it would be an easy fix for Congress if the court has misread its intent to fix that in the statute and provide that expert witness fees should also be recoverable. There are a number of practical implications that arise out of this opinion. Now that prevailing parties in copyright cases are not entitled to an award of non-taxable costs, the question is whether potential plaintiffs may be less willing to bring copyright cases because now they're no longer able to recover such non-taxable costs. And of course, they can be very substantial. However, on the other side, potential plaintiffs, and especially potential plaintiffs with deep pockets, may be willing to bring relatively speculative copyright cases because now there's no longer the threat that they will be liable for a defendant's non-taxable costs. And of course, it may also affect the way that parties approach settlement because the party with a stronger case can now no longer use the threat of non-taxable costs for leverage in settlement talks. And of course, it may also mean that at the end of the day, parties may simply become more cost conscious when it comes to such non-taxable costs and reduce their spending on such non-taxable costs, importantly and notably expert witnesses. And now we'll turn it over to Dan to talk about the next Supreme Court opinion, Fourth Estate Public Benefit Corp.
Right, so this case was issued on the same day, March 4th, 2019. This is another case that has very strong practical implications for copyright litigants and copyright owners. The question presented in Fourth Estate Public Benefit Corporation was whether registration of a copyright claim has been made within the meaning of 17 U.S.C. Section 411A when the copyright holder submits an application to the Copyright Office, as the Fifth and Ninth Circuits had held, or only when the Copyright Office actually acts on that application, as the 10th and 11th Circuits had held. This is another case about statutory construction, so let's look at the statutory language of 17 U.S.C. section 411A. It says, no civil action for infringement of the copyright in any United States shall be instituted until pre-registration or registration of the copyright claim has been made. And really the words has been made are the focus of the court's analysis in accordance with this title. The court also allows for a lawsuit to be filed after an application has been made if the application has been refused. So that's the statutory backdrop. This presented a circuit split, and the split has come to be known as the application approach versus the registration approach. In the application approach, which the Fifth and Ninth Circuits have adopted, that essentially holds that if a copyright holder files an application, deposits the copy of the work, and pays the fee as required by Section 408 of the Copyright Act, which sets forth the requirements for an application, the copyright holder has made the required registration within the meaning of Section 411A. This was held by Cosmetic Ideas, Inc. versus IAC Interactive Corporation in the Ninth Circuit in 2010, and by a Fifth Circuit case much older from 1984 called Apple Barrel Products. On the other hand is the registration approach, which was adopted by the 10th and the 11th Circuits, which essentially holds that a copyright owner may not sue infringers until after the Copyright Office has acted on the application by registering or refusing to register the copyright claim. This is the Fourth Estate case that made its way to the Supreme Court recently, and another case from the 10th Circuit in 2005 called La Resolana Architects. So let's talk about the benefits of the application approach, which the Cosmetic Ideas case from the Ninth Circuit recognized. The court said that the application approach avoids unnecessary delay in copyright infringement litigation, which could permit an infringing party to continue to profit from its wrongful acts. We can all understand how this could happen. If a copyright owner has not registered his or her work and identifies infringement, it certainly is the case under the application approach that that applicant could get an application on file within 24 hours and be in court the next day. That's not the case under the registration approach, and the Ninth Circuit was concerned about that. The court also recognized that the application approach avoids delay without impairing the central goal of copyright registration, which is to incentivize registration to maintain a robust national register of copyrights. The court was also concerned that in the worst case scenario, the registration approach could lead to a party losing its ability to sue because of the statute of limitations. We'll revisit that in a little bit. And the court also noted that the registrar's decision of whether to grant a registration is largely perfunctory and ultimately reviewable by the courts, essentially saying, what's the big deal? Why bother to wait on the Copyright Office to act on the application? Let's just let the lawsuit move forward. On the other hand are the benefits of the registration approach. And in essence, the courts that have applied that approach have done so in the interests of supporting a more fulsome record of registration. Congress over time has recognized the problem with people who want to use a copyrighted work, to license that work, to create a derivative work, to make some use of it, but they don't know who the copyright owner is because there is no registration for the work. This has been referred to as the orphan work problem, and it runs counter to the fundamental interest of the Copyright Act, which is to promote the creative development of new original works of authorship, including works based on other works of authorship that already exist. So the registration approach is really intended to promote as much registration as possible. There are other reasons to register works that we won't go into detail here. 17 U.S.C. section 412 says that subject to certain exceptions, parties cannot obtain statutory damages or attorney's fees if they don't timely register works in advance of filing a lawsuit or in advance of infringement. So there are certainly good reasons to register. So the Fourth Estate Public Benefit Corporation case is what made its way to the Supreme Court to address this issue. Like the Rimini Street case, the facts are not critical. Fourth Estate is an independent news organization that owns right in certain journalistic works. It licenses those works, which are later sub-licensed, but Fourth Estate maintains the right to sue. WallStreet.com was the defendant, which had secured a license, later canceled the license, yet continued to use the works. Fourth Estate sued it and sought an injunction and damages. And before filing the lawsuit, it filed an application for registration, but it did not wait for the office to act on the application, and the case was dismissed. Before getting into the holding of Fourth Estate, I'd like to talk for a moment about the amicus briefs that were filed. There were a number of them in support of each side. The amici for the registration approach included the Washington Legal Foundation, Public Knowledge, and various authors and educators. They were essentially concerned with limiting the record created by registration. Public Knowledge made an interesting point. They said the record created by registration is substantially diminished under the application approach because rather than being a substantially comprehensive list of ownership, the record reduces down to those works which have been or will soon be litigated. That often is true, as many of us know from practice, that somebody wants to bring a lawsuit, has yet to register, and the need, the impetus to bring the lawsuit is what also causes them to seek out registration for the first time. On the other hand, the amici for the application approach were essentially concerned with the litigation part of copyright infringement. The ABA, the American Bar Association, said the application approach ensures that copyright holders may go to court to obtain injunctions or temporary restraining orders to prevent or restrain infringement of a copyright as early as possible. The Copyright Alliance also recognized the potential inability or at least challenges that a plaintiff might have in obtaining preliminary early injunctive relief under the registration approach. And that's because, again, a party who knows that a work was infringed can't get to court the next day seeking an injunction, and really the timing of that is at the mercy of the Copyright Office acting on the application. So the holding of Fourth Estate, Justice Ginsburg wrote for a unanimous court, and the holding was, we conclude that registration has been made within the meaning of Section 411A, not when an application for registration is filed, but when the register has registered a copyright after examining a properly filed application. This was another textual analysis of the Copyright Act, and the court looked at several other provisions that refer to applications and registration and the language used, and really tried to draw and noticed a distinction in the statutory language between an application and a registration, meaning they're not one and the same thing. A registration is not something that an applicant controls, but it's actually something that the Copyright Office does. And here's a few statutes that offered support for the court's view, Section 409 and 410. Again, the court was concerned with surplusage from other statutes that would have been inconsistent with the application approach. There's an example of a provision that's arguably inconsistent with the court's holding. Section 408 says the owner of copyright or of any exclusive right in the work may obtain registration of the copyright claim by delivering to the Copyright Office the application materials. That suggests that the applicant has some control over when registration is made, but the court found that on balance, the statutory language does not support that result. The court did recognize and talk about statute of limitations problems, which we've seen some people were concerned about with the registration approach. The Copyright Act has a 3-year statute of limitations in Section 507B. The court held it was not concerned by the statute of limitations problem, stating, Fourth Estate's fear is overstated, as the average processing time for registration applications is currently 7 months, leaving ample time to sue after the registrar's decision, even for infringement that began before submission of an application. And upon registration of the copyright, a copyright owner can recover for infringement that occurred both before and after the registration, so there was no concern about substantial prejudice to plaintiffs. However, there is some authority, including a 1992 case from the Southern District of New York, which held that a plaintiff's copyright claims were barred by the statute of limitations despite a 2-year administrative delay in the processing of the claim in the Copyright Office. The court held that that delay was a self-induced problem of the plaintiff, in that the plaintiff could have promptly sought registration upon creating the work. It's unclear if there'll be more cases like that. Maybe more courts will decide that it's unfair to hold an administrative delay against a plaintiff under the registration approach, but people should be mindful that those rulings exist. The court mentioned pre-registration as a potential solution. Pre-registration, we saw it earlier in the statute. A claim can be made in court upon pre-registration. As a matter of fact, pre-registration is only available in pretty limited circumstances, and people don't take advantage of it very often. The court said that if a copyright owner is preparing to distribute a work of a type vulnerable to pre-distribution infringement, like a movie or a musical composition, the owner may apply for pre-registration, and that once pre-registration has been made, the copyright claimant may institute a suit for infringement. So this is a situation where a claim can be made before a registration certificate has issued from the Copyright Office. There are other limitations of pre-registration that are important to note and that really limit it as a viable option. A work is eligible for pre-registration only if it is unpublished, if it is being prepared for commercial distribution, and if it falls within a class of works that the Register of Copyrights has determined has had a history of infringement prior to authorized commercial release. And even if pre-registration is obtained, there still is a requirement that not later than 3 months after the first publication of a pre-registered work, the applicant must apply for registration. Just to focus on the specific requirements for pre-registration for a moment, prepared for commercial distribution, this means that there's a reasonable expectation that the work will be commercially distributed to the public, and that preparation of the work has already commenced, like a recording or filming of a movie. And then these are the works that have been enumerated as having a history of infringement prior to commercial release: motion pictures, sound recordings, musical compositions. There are others. So a possible effect of this ruling in Fourth Estate is that more copyright owners will avail themselves of the pre-registration requirement so that they'll know they'll be able to run to the court quickly if necessary. Another solution, which is probably the most likely option to address the registration approach, is special handling at the Copyright Office. This is essentially seeking an expedited processing of an application. It's readily available and widely used. Expedited applications cost about $800 each. The standard filing fee is only $55. That difference might not seem too significant for a copyright owner who's contemplating filing a federal lawsuit for infringement, but there are many cases that involve 10, dozens, hundreds, maybe thousands of works, such as musical compositions that are streamed or episodes of television series. That cost difference in particular could get substantial, and it could become a factor that more plaintiffs consider in deciding whether they want to sue and how they want to frame their lawsuit. The Copyright Office grants requests for special handling, in particular when there's a claim that's pending litigation or involved in prospective litigation. And generally, special handling takes about 5 days. However, it's unclear if the registration approach and this ruling will increase the administrative burden on the Copyright Office to the point that even claims for special handling take more time. The Supreme Court seemed to recognize some unfairness, the potential delays in the registration approach, and like in the cost issue, acknowledge that Congress might want to step in here because the delays in the Copyright Office processing of applications are really generally no fault of the parties who are seeking application, and they involve staffing and budgetary shortages that Congress can alleviate, so it's potential that Congress will want to step in and do something about this. It's also worth noting that in not every case, registration is necessary. In the situations of live broadcasts, registration isn't necessary. However, a party that wants to seek protection over a live broadcast must make registration within 3 months after the first transmission of the work. And that probably means that those parties will need to seek special handling because based on the typical 7 to 9 month processing period, it won't be possible to make registration within 3 months under the meaning of that term as the court just interpreted it. Foreign works are also generally exempted from the registration requirement, so they would not be subject to this analysis. Finally, to talk about some practical implications of this ruling, what is it likely to do? It's likely to encourage registration before infringement occurs. At least that's certainly the hope of the court and of Congress in the way that the court interpreted Congress's intent. It might delay the filing of lawsuits after infringement is identified. Again, you can't just run to court by submitting an application. The timing is to some extent outside of the plaintiff's control. It'll likely promote special handling and maybe pre-registration for sophisticated parties who know what that process is all about. There will likely be statute of limitations issues to delayed claims. There might be barriers to injunctive relief, which is something to be mindful of. And then there might be barriers to filing timely counterclaims in certain cases, counterclaims for infringement, where defendants are often on the clock, especially to file compulsory counterclaims. And if they need to register their works before filing a counterclaim, that could create difficulties that the courts have yet to address. And there also are likely to be, and in fact have already been, voluntary dismissals of certain pending infringement lawsuits that were filed while an application was pending but before it was processed. And of note, this seems to have happened in the high-profile cases about dance moves that were filed against Epic Games involving Fortnite. At least certain of the copyrighted dance moves in those cases, applications had been submitted, but the Copyright Office had not yet acted on them. And at least some of the cases had been dismissed without prejudice, supposedly awaiting registration so that they could be refiled. One final point that Viola and I both found was interesting is that both of these cases came out of the Ninth Circuit and were reversed unanimously by the Supreme Court, which in fact is not a big surprise.
Right, and actually between 2006 and 2015, the Supreme Court heard 160 cases from the Ninth Circuit and reversed 106 decisions and vacated another 24. And that is a reversal or vacating rate of 81%, which, as the chart indicates, is the highest rate among all circuits.
So especially in these cases involving copyright litigation, which arise so frequently in the Ninth Circuit, the fact that the Supreme Court reversed essentially 9-0, 9-0 unanimously is a little bit surprising, but these numbers suggest that we shouldn't be surprised. Thank you very much for joining us today. If you have any questions or would like to continue this discussion, we'd be happy to do so. Our contact information appears on the slides. You can learn more about us and our firm at www.quinnemanuel.com. And stay tuned and keep your eye out for more Quinn Emanuel webinars. Thank you very much.
Thank you.